Hello, my name is LAKSHAYA and I'm an intern at LEXIS and Co. I'm a third year law student at New Law College, Pune, and the topic is Impact of COVID-19 on Contracts. This is the part 2 of the video. Part 1 was left at what was force majeure. Now we are going to listen to the terms of impossibility and frustration. The terms of impossibility and frustration are frequently interchanged. It's crucial to note, however, the English common law frustration differs from the statutory provision of supervening impossibility and illegality under Indian law. This has an impact on how contracts are read differently under English and Indian law. The party must prove frustration of contract in order to be excused from an inability of performance under an English law regulated contract due to COVID 2019. Whether or not contracts allow for the use of frustration doctrine is determined by legal theories developed in English courts. These include A. Insinuating terms in the contract, B. Empowering courts to assess what is just and reasonable in certain situations, and C. Engaging in contract construction based on the parties' intentions. The legislative provision under Section 56 of Indian law, on the other hand, establishes the positive rule of law on supervening inability of illegality that renders the execution difficulties in the practical rather than literal sense. When a court finds out that an entire purpose or basis of a contract was frustrated by the intrusion of occurrence of an unexpected event or change in circumstances that is so fundamental that it is regarded as law as striking at the heart of the contract as a whole, relief is granted on the basis of subsequent impossibility. The contract would then come to an end on its own. As can be seen, the preceding considerations are highly fact and contract specific. Lord Denning J. noted in the first paragraph of the article that parties cannot be expected to have the foresight of prophet or his lawyer with the draughtsmanship of charmer. In an appeal, however, Justice Viscount dismissed the role of courts in suggesting terms and what is the just and reasonable into contracts, or emphasizing the parties' fate and entirely depend on the contract's design. Parties may not be justified in using drastic measures in times of crisis, such as COVID-19 outbreak. As things stand, parties will have to examine their contracts very carefully. In addition to the contractual wording, understanding the company's commercial operations and transactions in the relevant industry and sector, as well as the crucial material adverse change clause, for example, is a clause akin to force majeure and protect parties from unforeseen adverse changes in the circumstances in mergers and acquisitions. When determining whether the material adverse change clause can be used in specific situations such as COVID-19, the aforementioned practical considerations in the context of mergers and acquisitions must be considered, such as impact of COVID-19 on the transaction, the language of material adverse change clause, and whether it provides a suitable remedy to formulate requirements. Furthermore, court contract interpretations in unforeseen occurrences, conflicts, and rifle with varied complex methods, all of which are too highly reliant on the nature of contract and wording of the provisions to protect themselves on both sides of performance, allocate risk appropriately, establish strategy for renegotiation if necessary, and preserve the integrity of contract. Parties should seek legal assistance, conduct a complete legal examination of their contracts. That was all for impact of COVID-19 contracts. Thank you and have a great day.